Earned for the day. Julie Rendelman, our LAWNEWZ trial analyst, is here along with me. Julie, this has been a day of a few more bombshells. We've had some big ones yesterday. Jason Autry on the stand. First thing I wanted to get into is just the issue with cross-examination. I've never seen a cross-examination like that before, where the defense was basically just letting the witness retell his story all over again.
I actually thought, I think maybe it was Kathy that had talked about the fact that on direct, he sounded a bit rehearsed. He sounded a little too calm for my comfort. But then it seemed on cross-examination, he became more credible because of the way she was questioning him. I didn't really see her calling him out on anything at all. In fact, all she was doing was basically having him reiterate every single thing he had said before, which to me just kind of enforced everything he had said before. So I wasn't really full. Maybe I'm missing how the cross-examination is supposed to go. But based on my experience, that's not how it's supposed to go.
Well, yeah, I mean, it's the sort of cross-examination that needs quick, succinct, closed-ended questions, because people are talking about this thing turning into a fiasco from a defense standpoint, and it's like, look, you've got a witness on the stand that's admitted to lying before, right, time and time again. The way to deal with that is to stretch that out basically as long as the judge will let you go.
Well, you also want to be, this is the time when you want to be in control of the witness. When you're the prosecutor and you're on direct for the most cases, especially when you have a victim, for example, on testifying, you want the focus to be the victim. In a case like this, where this individual's on the stand, the defense attorney wants the defense attorney, in a sense, to be the focus. You want to hit him in every which way to show the jury that he is not credible. And quite honestly, I was shocked to feel afterwards that I found him a little more credible than I expected to find him. And it I kind of felt like she helped me feel that way.
Yeah, I mean, I was sitting there looking at that. I kind of wish I was here with you last night, because we probably both would have had plenty of things to say about it. But, I mean, part of this, I wonder if it's lawyering skill, and part of it, I wonder if it has to do with some of the rules for evidence and witnesses in Tennessee, because based on what I can tell, they allow surprise witnesses in Tennessee. They don't require witness lists be traded before trial. So from a trial management standpoint, is some of this the result, also discovery being handed over? You can't do a really strong cross unless you have access to some of the discovery.
But I didn't, and again, I didn't hear the in between when this person was testifying, but I didn't get the sense that the defense attorney didn't have the discovery. Am I incorrect? Because it seemed like she knew kind of the areas of which he had spoken about before. So she didn't just receive the discovery prior to him testifying.
Well, there have been complaints all the way through the trial,
sure,
that there wasn't enough discovery, and it seemed to me that some of what she was trying to do was get him to say what route he had taken, to sort of explain some of the other cell phone records, which then backfired, because he says, oh yeah, there's a bar near the scene where we, try to ditch the body.
One of the things that bothered me, that stood out to me, was not only just, that in terms of her cross-examination, not necessarily feeling that she was hitting it as hard as she could, but from the sense of the judge, that I felt like once again he is prejudicing the defense attorney, because here you had the prosecutor having all this time to question this witness, and then I remember at one point the defense attorney goes, "Judge, it's like 85 degrees in here, no one's paying attention, everyone's exhausted, and you're basically pushing me to finish this cross-examination." And he's like, "Well, you've been covering things, you should cover them kind of more quickly," which I found to be so honestly offensive. Nothing could be more important than a death penalty case, and it should be important not just to the defense attorney, but it sure as hell should be important to the judge, and it doesn't feel like it, certainly not when it comes to the defense. And I feel like at every turn he shuts them down. So maybe she's broken, I don't know, or maybe maybe cross-examination's not her strong suit.
Well, it might be both. My suspicion is that it's a mix of that. It's a mix of the rules that are being used in Tennessee, things like that. So, if you can call surprise witnesses, where there's been accusations of that at least once in this case, now not Autry, but others, where the defense had no clue that those witnesses would even be called.
No, I understand that. I understand that, and trials are not supposed to be trials by ambush, and it does feel like that in this case. It feels like things are just kind of thrown at the defense attorney, and she kind of has to make things up as she goes along. But I'll give an example, and sorry to switch topics, but I think it was the detective that testified today, and there was a perfect example in the detective. She's reading notes about the detective referring to the family not being forthcoming and not being truthful in regards to this investigation. She asked him maybe a question, maybe 2 questions, and walked away from it. I couldn't believe how she handled it. I don't know how she wouldn't have gone after him, because quite honestly, I thought that was huge. And there was so much to explore with regards to that.
Yeah, I mean, I'm really beside myself with the way that this whole case has been going. We've got accusations of surprise witnesses. Sometimes sometimes the defense just hasn't even been ready. But then, on the flip side, she's saying there are 100 possible witnesses. How many files am I expected to shovel in and out of the courtroom every day? And it's like, from a simple trial management standpoint, I mean, in the cases that you handle, how does this usually go? Well,
it's funny, when we talk about federal court definitely has a similar feel to this, but nothing like this. And federal defense attorneys are constantly saying it's not fair the way we get the jinx material. It's just not, we get things too late. But even in that situation, almost all judges require prosecutors to turn over their paperwork for enough period of time prior to trial. Here, it seems like it's just kind of follow your own rules. The prosecutor wants to call a witness, they call a witness. They want to turn over paperwork, they turn over paperwork. There seems to be no accountability by the judge to make sure that the prosecutors are kind of doing right, and just merely putting a witness on without allowing the defense attorney to prepare themselves is not in any way doing right by anyone, certainly not the defense attorney, certainly not the defendant. And I'm confident that he is going to have plenty of appeals, issues if he ends up convicted.
Yeah, I mean, this thing is going to be a appeals, I don't know if I want to say circus
extravaganza.
Or what. Yeah, extravaganza, that's a good word for it. There have been issue after issue after issue, and I wrote part of an analysis on some of the big issues that we've got up on LAWNEWZ.com, but I'm not quite sure where to think about where this thing is going. And we had some witness bolstering today. They called the cable guy to try to prove that Autry was correct in saying that cable was being installed on the day that Bobo went missing, and it's just kind of like
that. See, that in and of itself doesn't bother me, because since if we're going to argue that this is the only real witness that can say that in fact this defendant did commit this crime, then the prosecutor inevitably is going to want to corroborate little parts of his story to establish they're true. And so, while this is to me a small thing, it's certainly something that they can at least say, when he told you this, we know it's true, not just because he said it, but because there's other witnesses that came in. However, when we start to talk about some of the issues that came up in regards to the witness's background, and the judge found that to be collateral, that's where I started to have some issues.
Well, we've been back and forth about this whole collateral matter issue. So it's like the cable guy comes in when, in theory, I would turn around and say, how is that relevant to the key issue? But evidence that the star witness, Jason Autry, is a member of a white nationalist group, that doesn't come in.
Not only is he a member of a white nationalist group, or at least was. I'm sorry.
Yeah,
he
says he was. Well, he's incarcerated now, so maybe he's not.
Right.
The next question is, when did he stop being a member?
But one of the other issues, what she had tried to bring out, is that part of being a part of that group is that you're not allowed to rape a white female, and so he wouldn't to try to show the jury that he wouldn't want to admit that, because if he admitted that he had partaken in the rape of this young woman, then that would cause problems with him within his group, which I think is absolutely relevant. And how the jury shouldn't know about this individual, his background, his bad acts, to make a determination as to his credibility when he is the only witness that can corroborate and say that this is the person that committed this crime, is beyond me.
Yeah, that doesn't make any sense to me either, and I think it's a misapplication of the law in Tennessee. The whole idea of this collateral issue, collateral fact, collateral whatever you want to call it, there's a couple different versions of what's ultimately the same rule, is it's ultimately a relevance rule.
Right.
What it basically says is that if it's a collateral issue, first of all, my understanding of the rule is you can ask the witness about it. You just can't bring in a bunch of other evidence to prove that the witness is. So let's say, for instance, if Autry got up on the stand, and the jury was there, okay? And the defense said, were you a member of the Aryan Nation? And he said
it.
no. Then the rule would kick in.
Correct.
At that point, the rule would kick in to say, she can't show him a membership log or a Facebook post.
Well, she
or,
actually, no. She would probably be allowed to show him that. The issue would be she wouldn't necessarily be allowed to bring in a witness, like a friend of his from the Aryan group, saying he's a friend of mine and we are in a group together. That would
I'll give
be
you
the
that.
collateral.
So she could refresh his memory, but,
Sure.
but she.
Although in this case, you can't even refresh anyone's memory, if you remember correctly.
Oh yeah,
you can't
with,
do
the,
anything.
with the mother, you can't refresh the mother's memory.
Right.
You can't refresh memory. You can't. Well, that was partially a problem because, and that's part of the analysis I've got up on LAWNEWZ, is that the defense was correct. The prosecutor flat out misstated the law. Flat out misstated the law. Didn't offer a correction, to my knowledge, at any point in the proceeding, which is required under the rules of professional conduct. The judge misconstrued the issue, and then the defense backed down.
Right.
So that was an issue from every single officer of the court's perspective.
One of the things, and I could go on for days, but one of the things I also noticed was sometimes when I'm watching, I'm like, the jury must not be there when they're arguing, because when we have issues of law, we always go to sidebar when you're on trial, especially when you're on trial with a case this serious. You always go to sidebar because you don't want the jury to hear kind of the back and forth, because the back and forth is revealing that of which the jury's not supposed to know about. But I tend to notice that every single time there's an issue, it's done before the jury, which is unheard of. So the jury's basically partaking in every ruling that the judge is making on things that aren't supposed to go in front of the jury. And since they're almost always against the defense, they're hearing even more about things that they should not be hearing that is prejudicing the defense.
Yeah, I mean, this thing has turned into a fiasco. There were a couple of other interesting pieces of nuggets, I should say, of information that came out in the witness stand. We heard this accusation yesterday from Autry that Clint Bobo, the victim's brother, was somehow in cahoots with the defendant, and it came out on the witness stand, and then everybody just dropped the issue and didn't go any further with it. Well, today we had an investigator from the Bureau of Investigation in Tennessee on the stand, and he started to get into a little bit of this issue of how much investigators really looked at the Bobo family themselves, the victim's family. I want to listen to a little bit of the cross-examination of him.